Good afternoon, everyone, and welcome to this Carlton Fields webinar on Florida's Uniform Commercial Real Estate Receivership Act. Before we get started, Ben, if you could go to the next slide, we just wanted to inform everyone that this webinar is being recorded for educational and training purposes. This recording may include questions and poll responses provided to you during the live event, and this recording will be made available after the conclusion of the live event and posted on the Carlton Fields website. I'm Naomi Berry. I'm a shareholder at Carlton Fields in our Miami office, along with my colleague Yolanda Strader. We both have several years of experience assisting lenders and servicers with enforcing commercial loan documents, including commercial real estate loans in both state and federal courts. We recently authored an article that was published in the Daily Business Review discussing the Uniform Commercial Real Estate Receivership Act, or UCRERA. And our colleague Jordan Haynes from the Tampa office works in our firm's real estate and commercial finance practice group, representing lenders and developers on a wide range of complex commercial real estate and finance matters. In addition, Jordan has represented lenders and servicers with enforcing commercial loan documents and has extensive experience representing court-appointed receivers. And before we get started, I just wanted to let everyone know that we will be taking questions through the webinar. Please feel free to ask your questions using the Zoom Q&A feature at the bottom of your screen. It may be at the top, depending on your setup. We'll answer those questions at the end of the webinar. And if there are any questions that we can't get to, we'll be happy to follow up with you after the webinar. So next. What is the UCRERA? Florida enacted the Uniform Commercial Real Estate Receivership Act effective July 1st of this year. It was drafted in 2015 by the Uniform Law Commission and has now been adopted by 8 other states. In addition, legislation has also been introduced in Connecticut. In Florida, it's codified at Chapter 714. And one thing that's important to note, although it's been adopted by these other states, many of them are non-judicial foreclosure states, so that it may be interpreted differently if we look at other states for case law. Next slide. So what is a receiver? A receiver is a person who is appointed by the court as the court's agent and, subject to the court's direction or authorization, takes possession of, manages, sells, transfers, leases, or otherwise disposes of receivership property. Next. The purpose of the UCRERA was to provide a clear standard for receivership appointment and set forth a receiver's powers and duties. Florida's task force found that existing receivership law in most states, including Florida, does not adequately provide a clear standard for receivership appointment or set forth a receiver's powers and duties, and such lack of statutory guidance causes variation from one county to the next, as individual judges differ on when receivership is an appropriate remedy. And I would add, it could cause variation even within the same county among various judges. So we're very excited to have a much clearer framework. Next slide. Now, there's no independent cause of action created by UCRERA. As under the common law, the appointment of receiver remains an equitable secondary remedy that may be requested in an existing case, such as a commercial foreclosure action. And it's important to note that while loan documents may provide for the appointment of a receiver upon default, discretion still remains with the court. The UCRERA sets forth factors for the court's consideration, but even where a borrower consents to the appointment of a receiver in the loan documents, it's not necessarily guaranteed. Note also that the UCRERA does not cover the homestead of an individual owner or the owner's affiliate, exempt or personal property that's primarily used for personal, family, or household purposes. Next slide. And the statute specifies, among other things, when and how a court may appoint a receiver, while ultimately leaving appointment to the court's discretion, as I just mentioned. And pre-judgment, the standard is where a property is being subjected to or is in danger of waste, loss, substantial diminution in value, dissipation or impairment, or has been or is about to be the subject of a voidable transaction. Post-judgment, the standard is to carry the judgment into effect or to preserve non-exempt real property pending appeal or when execution has been returned unsatisfied and the owner refuses to apply the property in satisfaction of the judgment. Next slide. And a receiver can be appointed without notice to the owner under certain circumstances. The entity seeking appointment of the receiver files an affidavit or verified pleading that reflects that immediate or irreparable injury or loss will result to the entity, or that waste or other diminution in value will result to the real property before the owner can be heard in opposition. And the move-in's attorney must satisfy that she made an effort to provide notice to adverse parties or explain why notice should not be required. And if a receiver is appointed without notice to the owner, the order must include specific features, including an explanation of why the order was granted without notice. Next slide. Now, in connection with foreclosure or enforcement of a mortgage, the court shall also consider the following in deciding whether to appoint a receiver: whether the mortgagor agreed to appointment of a receiver on default, whether the owner of the property agreed in a signed record to appointment of a receiver after default, whether the property and other collateral are not sufficient to satisfy the secured obligation, whether the owner is failing to turn over to the mortgagee rents that it was entitled to collect, and or whether the holder of a subordinate lien obtains appointment of a receiver for the property. Next slide. And here I'm going to turn it over to Jordan Haynes.
Thanks, Naomi. Hopefully everyone can hear me all right. Naomi was too kind to not point out that I look nothing like the stock firm photo that was on slide number 1. So I am Jordan Haynes, and I am happy to be a part of this presentation, and thank you all for joining. My portion of these slides will include a little bit more of the nuts and bolts about the actual act and the appointment of the receiver. Again, as Naomi pointed out, a lot of my work has been representing court-appointed receivers, so I'm very excited for this new statute and what it provides to lenders and receivers as providing guidance. So getting right into it, who can serve as a receiver? The Act has stated that an individual who is not disqualified. So what is disqualified? So the individual, the receiver, has an interest, they are disqualified if the receiver has an interest materially adverse to interest of one of the parties, has a material financial interest in the outcome of the action. And again, this does not include the receiver's compensation. This is separate from that. Or if the receiver, if she has a equity interest in one of the party, and again, this doesn't include stock in a publicly traded company. So if you own stock in the lender, and that will not disqualify you as becoming a receiver. The receiver has a debtor-credit relationship with a party or is an affiliate to one of the parties in the litigation. Next slide, please. So moving on and continuing with who can be a receiver, a person is not disqualified, and these overall go into the nature of the receiver being an independent arm of the court. So a person's not disqualified if they maintain a bank account with a party to the lawsuit, if the receiver was in another unrelated matter already as a receiver, if the receiver was owed compensation to an unrelated matter, was engaged by a party in a matter unrelated to the receivership, or is an individual obligated to a party on a debt that is not in default. So again, if you have the receiver has a loan on their house and it happens to be with the lender seeking the appointment of the receiver, that would not disqualify. But again, it goes into the independent arm of the court. That's the role that the receiver plays. Next slide, please. Okay, so the mechanics of appointment. Typically what we see is we have the plaintiff, who's the party seeking the appointment of the receiver, will file a complaint and include a count for the appointment of receiver. They'll also file a separate motion to appoint receiver. In that motion, the party that's seeking appointment will propose a qualified person with experience with that particular product type. So if the mortgage property is, let's say, office space or a mall or hotel or mini storage, the motion will put out there how the receiver has experience with that certain product type. And the motion will also include a statement about the experience and usually include either a CV or a resume of the receiver, again, outlining how the receiver is qualified to step in and be appointed as receiver. But as Naomi pointed out, it should be noted that the plaintiff or the party seeking the receiver will put forth an individual in their motion, but ultimately it's the court who decides, and they're not bound by the person that the moving party puts forward. So once the receiver is put forward and the order is entered, the receiver must post a bond or an alternative assurance. This can be a letter of credit. Now the statute does not give guidance to the amount for the bond. And so that's something that needs to be considered. You know, there's a lot of factors that go into it, but the statute does not specify or give guidance as to the amount. The court does not have to wait until the bond is posted before the court can authorize the receiver to act, as long as it's necessary to prevent or mitigate immediate injury, loss, or damages to the party who sought the appointment of receiver. Again, the statute provides protections and guidance to the receiver, and in the new act, it has that the bond, that the receiver's bond must be a claim against the receiver's bond must be made no later than 1 year after the date of the receiver's discharged. And one thing I want to point out is that the act doesn't go into discharge of the receiver, but one thing that we always like to do when we're representing the receiver is make sure that there's a solid order entered by the court that discharges them, and we try to put on there that the receiver has fulfilled and discharged all of her obligations, and the actions taken by the receiver in the exercise of her duties under the receivership are approved, ratified, and confirmed by the court. Again, this is just one more instance where trying to protect the interests of the receiver and also protect against any claims against the receivership. Next slide, please. What the new act has added is that it has created that the receiver has a status as a lien creditor. The act has borrowed several concepts from the bankruptcy code and provide that a receiver and receivership property with certain rights and protections similar to a bankruptcy trustee, if you're familiar with that. The act allows the receiver to recoup receivership property or recover receivership property similar to Section 362, which is the stay provision of the bankruptcy code, and 542, which is the turnover provision of the bankruptcy code. Now, something to keep in mind is the rights that have been provided are ratcheted back from what is in the bankruptcy code. And so I just want to run through that so people are aware that they don't think that it's something that is automatic. So with reference to the stay. So the stay is not automatic or mandatory as it is in bankruptcy. The stay is permissive and has to be requested. The stay order has to have a special title so the parties that are not part of the action can get proper notice. And to be bound by the stay, a person has to have actual notice. The Receivership Act also adds in that the receivership property includes not only the real property, but also the personal property and all the profits. And going into the next slide, this is similar to the Bankruptcy 544 code, which is the strong arm statute. The receivers has a hypothetical, is a hypothetical lien creditor, and they come ahead of non-perfected interests, and the receiver can claim a superior interest ahead of all rents at a third-party claims to the entitlement of those rents. Statute 71411 provides that what a receiver can do, and the Act has on there that the receiver can require turnover of receivership property, clarifies what the receivership property is, and the statute is clear that if there's a perfected security interest that predates the appointment of the receiver, that it doesn't affect the rights of the superior creditor. So what can the receiver do? The receiver can demand from a person that is owning a mature debt or a debt payable on demand that they shall pay the receiver directly, and the person that's in possession, custody, and control of the receivership property has to turn over that property to the receiver unless, and there's a caveat in 3, which is that the property is subject to a validly perfected lien that depends on the creditor's possession, custody, or control of the property. And in those instances, the creditor does not need to turn it over until the court orders an adequate protection of the creditor's lien. So we'll go to the next slide. Okay, so the main takeaway through all this with this new act is that the scope of the receiver's authority prior to the act was largely determined by a case-by-case basis, and this is pursuant to receivership order. What the act has done is the act has codified the right to appoint the receiver and provided a statutory framework for the real property receiver. And these powers and duties that are outlined on this slide are some that you'd be familiar with in a typical receivership order, but what is now great for lenders and receivers is that these are now in the statute, so you don't have to have everything in the receivership order, although a practice tip is to basically copy and paste these and put them in the motion and also the order appointing receiver. So this act, it establishes general powers and duties of the receiver and also the owner of the property, which Yolanda will go into next. It requires court authorization for a lawsuit against the receiver. It also allows the receiver to sell or transfer receivership property other than in the ordinary course of the business with the court's approval. And again, it specifies the duties of the owners and also provides the authority for payment of the receiver's fees and also that the removal of the receiver for cause or to replace a receiver in certain circumstances. So again, just clarifying and codifying all of these things that are now in the statute. Next. Okay, so the powers and duties of a receiver. What can the receiver do? Again, similar to what you've seen in receivership orders in the past, they can get control over the receivership property. They can run the business that constitutes the receivership property, including incurring debts and pay expenses in the ordinary course of business. They sit in the shoes of the owner to file a lawsuit. Again, think about if there's an eviction claim that needs to be made. And it also provides an important power is the subpoena power over individuals. So if someone's not complying, if the owner's not complying or representative's not complying, the statute now provides the receiver with subpoena power. It also permits the receiver to engage professionals like lawyers and property managers and accountants and exercises powers that are conferred by the order to the receiver. And as always, if the receiver needs further instructions or court clarification, they can go back to the court. Okay, so next slide. So specifically, the Act provides the powers and duties of the receiver, and these powers and duties should be cited in the motion to appoint receiver and also should be cited in the order appointing receiver. And unless these powers are explicitly limited by the court, the receiver has the powers outlined in the Act. Again, this is over real property and post the enactment of this new Act, which was in July. The Act provides that the receiver can operate the business and the receiver can run the business and not just preserve the status quo. So they can incur debt, they can make improvements, they can transfer property, they can reject executory contracts, which Yolanda will go into. They can pay compensation to the receiver's professionals and make distributions of the receivership property. Those are all powers that the receiver may have with the court approval. Now, there's certain things that the receiver has duties and obligations to do, and those are to prepare and retain business records, account for the receivership property, file with the recording office a copy of the order appointing the receiver with a legal description of the real property that is part of the receivership estate. Okay. Well, next is my partner Yolanda will go through the key differences between the new act and the common law.
Thank you, Jordan, and thanks to you, Naomi, as well. Good afternoon, everyone. So as Jordan discussed, I am going to go over the key differences between UCRERA and the status of the law before that act was enacted, so you can get a sense of, in practical terms, what the difference will be. So we've discussed some of these points already, but again, it's important to note where there are points of departure from the common law. First, a receiver must file a statement under penalty of perjury that he or she is not disqualified from being appointed as a receiver. Jordan discussed what it means to be disqualified. So a receiver should be familiar with that language in the act. UCRERA has also borrowed some aspects from the bankruptcy world, like Jordan mentioned. And so after giving notice and having a hearing, the court governing the receivership can actually enter a stay that would stop others from obtaining possession of receivership property, or enforcing a judgment against that property, or even enforcing a pre-receivership lien against the receivership property. The court can also issue an injunction to protect against misappropriation or waste of the receivership property. UCRERA also expands the ability to get a receiver appointed after a judgment is entered. So before UCRERA was enacted, Florida courts generally found that post-judgment appointment of a receiver was unnecessary. Next slide, please. So what is likely considered to be the biggest difference now that we have UCRERA in place is that the law authorizes the sale of receivership property free and clear of any liens. But you should note that those liens would attach to the proceeds of the sale of the receivership property. So before a judgment is entered, a court may approve such a sale only if the owner provides consent or fails to object, and the receiver demonstrates that the sale will prevent certain things like waste, loss, or substantial diminution in value of the receivership property. A sale can also occur after a judgment is entered, and that process is less stringent than the pre-judgment process I just described. Next slide. So UCRERA also spells out an owner's duties when a receivership is established, and those duties include cooperating with the receiver, preserving and turning over all receivership property to the receiver, submitting to examination, identifying the relevant records for the receivership property, and frankly, performing any duty imposed by the court. So if there are additional duties you want in there, certainly make sure you include that in the order that appoints the receiver. So if an owner fails to carry out any of those duties, the court can actually award damages to the receiver. Next slide, please. Okay, so here's another aspect of UCRERA that borrows from the bankruptcy world. Jordan previewed this for you all. So with court approval, the receiver may adopt or reject contracts that have not yet been fully performed. So we call those executory contracts. And they include, for example, leases, maintenance agreements, utility agreements, those sort of things. A receiver is deemed to have rejected a contract if she does not adopt it within a reasonable time. Now, the Act does not define what a reasonable time is, and we suspect that that will probably be litigated at some point, and we'll see some sort of rationale or basis to determine reasonable time spelled out in subsequent case law. Notably, if a receiver simply performs under an executory contract, it does not mean that he's adopted it. So, for example, if the receiver continues to pay amounts due under a maintenance agreement, he still reserves the right to reject it with court approval. Next slide. So what are the consequences of rejecting? Oh, let's go back one slide. There we go. So what are the consequences of rejecting an executory contract? It's considered a breach of that contract as of immediately before the appointment of the receiver. And the party that did not breach the agreement must actually submit a claim for damages, and UCRERA spells out when that needs to be done. You should know that a receiver cannot reject certain unexpired leases. So, for example, the receiver can't reject a lease on a property if the property is the tenant's primary residence, nor can a receiver reject a lease if the receiver was appointed at the request of someone other than the mortgagee, the bank. So there are also certain circumstances when the receiver may still not reject certain kinds of leases, even if the bank, again the mortgagee, requested the appointment of the receiver. This includes when the lease is superior to the mortgage lien, or, for example, when the terms of the lease are commercially reasonable and the tenant had no reason to know that the lease violated the mortgage. Next slide, please. So UCRERA applies to receivers appointed on or after July 1st, 2020. So what do we do with the complete body of law that we had before UCRERA? Well, don't throw it out. It's still persuasive. It's still helpful. For example, in determining what amount the bond should be, you should look at previous case law to see what was decided. Next slide, please. And my colleagues and I have conferred about, what this act may mean going forward. Obviously, we're in the middle of a COVID-19 economy, so it's a little hard to tell if we're going to see more receiverships as a result of the uniformity and clarity provided by UCRERA, or if we're going to see more receiverships because the economy is what it is. But at the end of the day, I think it's fair to say that we will see more receiverships. We also predict that having a clear standard for the appointment of the receiver and the role of the receiver may lead to more diverse appointments, including the appointments of women and minority receivers. So Jordan mentioned this previously. UCRERA allows the parties seeking the receivership to nominate a particular receiver. Ultimately, the decision as to who will be named as the receiver remains with the court, but entities seeking appointment of a receiver should consider skilled professionals like property managers, asset managers, real estate brokers with experience in the relevant market. And with that, next slide, please. Naomi, Jordan, and I would like to thank you all for tuning into our webinar regarding the Florida's Uniform Commercial Real Estate Receivership Act. And we welcome any questions you may have. I see we have one in the Q&A box. But before we answer that, by all means, to the extent you have questions that you think of at a later time after we conclude this webinar, please feel free to reach out to us. Our contact information is on screen now and will be available in the presentation. So Naomi, Jordan, the first question I think we have is, does the bond have to remain, the bond for the receiver have to remain in place for 1 year after discharge of the receiver? And Naomi, I think you were going to answer that.
Sure, I'll take that, although the answer isn't 100% clear in the statute. The statute does not necessarily say how long the bond needs to stay in place, but intuitively, it makes sense that the bond should stay in place for a year after the receivership, because it should be in place until the expiration of the time to bring claims. It wouldn't be that helpful if the bond wasn't there anymore and somebody had a claim that couldn't be satisfied. So we think that it makes sense for the bond to stay in place. And we have another question. Does the receiver have to be an individual, or can we have corporate receivers? That's also a good question, which I don't believe is addressed specifically in the statute, but I mean, I think Jordan can probably speak to that.
In the past, and the statute has not changed this, is that it needs to be an individual acting as a receiver. Now, the receiver obviously can work for, we have receiver clients that work for large property management companies, and they can employ their management arm to help run the property during the pendency of the litigation and while the receiver is appointed. But the actual individual receiver is a individual. I think that's it. The one thing Naomi, if we have time, while preparing for this, that'll be interesting for the people that are on this webinar to see, and as things get litigated, is also, I anticipate, and I think that there's going to be more appointment of receivers post-judgment. The statute has, provided certain rights and obligations that lenders have post-judgment. And I had not seen that previously done a lot. I don't know, Yolanda or Naomi, if you had seen post-judgment receivers. I think there's now, because of the language in the statute, there's some value in that. So that'll just be something to keep an eye out, and interesting to see if that's something that helps. The other thing is, with these bankruptcy-like, bankruptcy-light provisions in the new act, I think it is more attractive for receivers to, sorry, a question popped up. More attractive for plaintiffs and lenders and servicers to have a receiver appointed because of the stay function or the turnover function.
Well, again, to the extent you all have any questions that you think of at a later date, please feel free to reach out to us. We'd be happy to address them for you. Naomi, Jordan, anything else before we conclude?
No, just a thank you to everybody. So thanks for including me, and look forward to working with this statute and seeing how it develops.
Same. Thank you, everyone.
Thank you.